Welcome back to another edition of War Story Wednesdays. You know how IBM had that banner, their tagline was think? Here's a story about an IBM guy that maybe needed to think twice about what he tried to do. IBM had an arrangement with a national real estate company that if they needed to relocate one of their executives, the real estate company would try to sell the house. And based on the appraised value of the house, if it didn't sell quickly, the real estate company would in turn buy the house from the executive and then sell it off later. And that's exactly what happened in this case. The IBM executive got transferred out of the state, couldn't sell the house, 3 appraisals were made, a value was determined, and the real estate company bought it. And then, several months later, resold it. At a loss, by the way. The real estate company couldn't get it sold for the same value of the appraisals and lost $99,000 on the deal. To add insult to injury, shortly after the deal closed, the buyer discovered some things that the seller had failed to mention, like the neighbors, who, well, they weren't the nicest neighbors to have. They would have really loud late-night barbecues.
Natch, be my guest.
Coupled with the late-night arguments.
You are no gentleman.
That went on and on and on.
Get out and get out.
And it wasn't something new. In fact, it turned out that the IBM executive guy had called the cops on the neighbors dozens of times before he sold the house. Yeah, you know that piece on the transfer disclosure statement that says, "Are you aware of any neighborhood conditions or nuisances?" He said, no. I guess I would too. So what happens to the buyers who now try to sue for damages or to rescind the sale? Frankly, they just don't want to live here at all. They sue the seller, and they sue the real estate company, which was actually the seller to them. And both of those defendants do what's called a demur. They file a motion with the court that says, dismiss the case because we have no potential liability. The real estate company says, we never made any disclosures. We never had an obligation to make any disclosures about the neighborhood because, well, we've never lived there. And the seller says, I didn't sell to these people. I sold to the real estate company. So I never made any representations to the second buyer. Therefore, how could I possibly have misrepresented to them? And the trial court agreed with both of those defenses and kicked the case out. So the buyers appealed. And the Court of Appeal looked at it a little bit differently. The Court of Appeal said that the IBM executive knew that the real estate company was merely a transition owner of the real estate, and that it was going to turn over whatever the seller disclosure documents that it got from the IBM executive to whoever the ultimate buyer would be. And the appellate court said that the trial court misconstrued evidence with respect to what it meant when the seller signed the transfer document. Because when the seller signed the deed, he didn't name the real estate company as the buyer. He left it blank, knowing that whoever was going to be the ultimate buyer would have their name filled in on the grant deed. And that evidenced the seller's intention that the property wasn't being sold to the real estate company, but rather the second buyer from the real estate company. Did the real estate company get out of liability on this case completely? Nope. In fact, it had to stay in the lawsuit. Not because it had liability for non-disclosure, but because since the buyer was suing for rescission, which means undo the deal, the real estate company was going to get the property back so that they could resell it again to yet someone else with adequate disclosures. So what's the takeaway on this case for you as a real estate brokerage? Imagine this scenario. You have an agent that did an inspection of property as part of a bank foreclosure. Back when the only way you could make a living was by giving brokers' opinions of values to banks, hoping that you would get the listing again from the bank when it was time to sell that property off. And as part of that broker's opinion of value, you noted that there was a leaking roof or a crack in the foundation. And you hand that document to the bank and it says, "Thank you very much," and it tucks it in the file. You haven't sold anything for 3 years and you get out of the business. And finally the bank gets around to listing the property with your brokerage. The broker that's now in charge has no idea about your report. Somebody else in the company gets the listing and sells the property. The buyer then sues because of the faulty roof and the cracked foundation, and says the bank knew about it and didn't disclose it, and that the brokerage knew about it and didn't disclose it. The bank's screwed because right there in its file is your report. Does the brokerage know? Does the brokerage anticipate that the report it provided to the bank years ago would be used or discoverable or should be disclosed to a subsequent buyer as a material fact disclosure? And the answer is yeah. If the brokerage has information related to a transaction that was done years ago or an inspection that was done years ago, the brokerage has an obligation to disclose that to any subsequent client, including the after foreclosure purchaser.